Good morning, everyone, and welcome to the October Risk Management Risk Reduction class, where today I'm going to cover some important forms. I've broken the forms into three categories. Hopefully, everybody got the handout and you have that available to you. You can access that alongside of accessing this webinar so you can follow me along on the forms. I'm going to talk about some important C.A.R forms, explain a couple, talk about a few challenges that agents seem to have. That's understandable. So I want to help you through that. I also want to talk to you a very important aspect of our E&O insurance, and that is selling your own or a relative's property, which would include flippers. Traditionally, E&O companies exclude agents representing themselves in a transaction. They exclude flips that are less than 18 months. In other words, you have to own the property for 18 months before they'll cover the transaction. Mike pays for an endorsement to cover those things. So yes, you can represent yourself. Yes, you can do flips. We have agents, certainly in San Diego. I'm more familiar with some of the agents' practices, not as familiar with all of you in Irvine. I apologize. I'll learn soon. But if some of you are actually also buying and flipping properties, investing in properties only to turn around and sell them later, I think that's a benefit that agents have with a license. You can accomplish that. And of course, one of the benefits is you don't have to pay an outside realtor to represent you in the transaction. So I've always negotiated with our E&O companies to get those sorts of transactions covered where normally by boilerplate they're excluded. They're not, but we do have a process we have to follow. So selling your own or a relative's property is the second concept I want to talk about. And then finally, I want to introduce some of you, remind others of some of the important forms that are in Agent Hub. Agent Hub contains a whole bunch of forms. I was going to count them, but I forgot to. But a whole bunch of forms. Some of them not so important. They were important at one time. They're kind of nice. If you need them, you should be familiar with them. Some are extremely important, I think, and a few of them are even required. So I want to walk you through the Agent Hub forms as well, and they're all in your handout. So let's get right into the class. Let me uh, find, where is it? Heavens. Help, I can't find my presentation. Oh, gosh. I've had a tough day today. I can just open up PowerPoint, I guess. Yeah, come on in. The door's locked. So I go, oh, I know where to go. I'm having a mental
There it is.
challenge. Yeah, that's right where it belongs.
Well, you have to share your screen first.
Find it. Yeah, so where's I want to find the folder. Here we go. All right, October. I apologize, everybody. Had a little interruption before the class. Now I can.
You got it?
I got it. Thank you, Lindsay. Folks, I could not do my job without Lindsay and Emily and now Erica. They are extremely important to the functioning of this company. They go a long way to making me look better than I am, and that's not an easy task, I can tell you that. Okay, sharing the screen. I hope I didn't. Yeah, share. Everyone can see my screen.
It's loading up.
Yeah,
We can't see it. Yep, now we can.
now you can see it. Okay. All right, let's jump right into today's class. And as always, if you're working, I want to be available. I'm going to take a little vacation soon, but that's okay. We'll make sure we're covered. So during the day, business day, if you call my direct line, that's pretty easy to reach me that way. My direct line on the screen there, and if I don't answer, I'll return the call. It'll go to voicemail. You can always email me, of course, at my email address there. And of course, evenings and weekends, and even during the day, I'm now more responsive to the cell phone during business hours as well. And so that my cell number is there on the screen. So it shouldn't be too hard to reach me. All right, so let's talk about some important C.A.R forms, some forms when selling your own or a relative's property, and some agent hub forms. So first of all, let's look at some C.A.R forms. And one of the things I want to talk to you about briefly is uh, authority documents. So representative capacity signature disclosure identifies who has the authority to sign for a trust, an entity, the power of attorney, or who's a guardian or conservator or administrator or executor of an estate. It does not grant them authority. That's important to know. Now, what a representative capacity signature disclosure actually does is it provides a primary level of protection to the person signing a document. So if I'm a trustee uh, doing something on behalf of my trust, when I sign a document, I have to sign my name. No document can be signed by the name of the trust, the name of the entity, the Walt Klein Family Trust. I can't sign that. Why? Because the Walt Family Trust doesn't have a hand. It can't sign anything. So clearly the trust didn't sign it. So the signer has to be a human being. In the case of a trust, it's the trustee. Some aggressive attorneys will go after the signer as well as the principal, in this case, the trust. And so the first level of protection is you are disclosing, or the signer is disclosing that, look, I'm signing stuff, but I'm doing it as a trustee, not as the individual who's doing the owns the house or selling the house. Or I'm signing this on behalf of the LLC, but the LLC is the seller. I'm not the seller, but I'm signing for the LLC. So this document identifies, it doesn't grant authority. That's where the mistake is in some agents' mind. They think that's an authority document. You, of course, want the representative capacity signature disclosure. We want that level of protection for our clients who are signing documents on behalf of their trust, their entity, their estate, whatever. But you also must provide an authority document. And the reason we want that is it has happened more than a handful of times. If it happened once, I wouldn't worry about it. I don't create any document, or I don't come up with any dialogue for something that happens one time. We'll deal with it. But something that happens repeatedly, then we have to make sure that we're dealing with it. So repeatedly, sellers will say, yes, I'm the trustee. They're not. They will say, I'm the only trustee. There are three trustees. This has happened multiple times. And the agent who represents the trust has some vulnerability because we are representing that these people have the authority to enter into a contract. Now, the paperwork of the contract, of course, gives us a level of protection because the people entering the contract are saying they have the authority to do it. So that would be my first line of defense should litigation start. But to avoid the problem in the first place, an escrow that won't close because we finally got a copy of the trust, and oh my gosh, there's two other trustees and one of them not so easy to get a hold of. Well, so the authority document in the case of a trust would be either the trust itself, we'd prefer not to get that, or a certification of trust. And that can go to the escrow, and then escrow can say they have it and they've reviewed it, and these are the trustees. That's okay too. But you've got to take, as an agent, you've got to take some effort to uh, discern whether or not the signer actually has the authority to sign. A power of attorney. Oh yeah, I have a power of attorney. Start signing stuff. Well, you need to see the power of attorney. That sort of thing. So that's the first thing I want to give everybody on the right page. Authority documents. When Lindsay asks for those things, or when Erica asks for those things, it's not the representative capacity signature addendum. It's actually the background document, that does grant the authority to whoever is signing to sign the documents. Hope that's pretty clear to everyone. All right, next I want to talk about the difference between basically the addendum and an amendment. An addendum and an amendment. I had a little summary sheet and I didn't have it, but that's okay. All right. So an addendum is a document created with the creation of the contract. For years and years and years, C.A.R has been sort of sloppy, and I've been sort of sloppy, and agents been sort of sloppy by just letting addendums apply to any change to a contract or even a change to a disclosure. Some of you can remember that one of the boxes that you could check up here on the top was TDS, an addendum to the TDS. Well, if you are changing the TDS, you don't use an addendum, you actually use an amendment to prior disclosure, which is an APD, and that's described up here in the paragraph. When you are creating the document and you have certain addendums that you want to attach to the RPA or the listing agreement, the addendum would be the appropriate document. Once you've entered into a contract, and now you want to change the contract between the buyer and the seller, or the landlord and the tenant, you would use an amendment to existing agreement. So that amendment is used to change a document and works sort of like a counteroffer, if you'll notice. You don't use counteroffers once a contract's been created, but an amendment sort of follows that. C.A.R went through all of their forms, and because all of them said addendums, when in fact many of them were used as amendments. I'll give you a good example of what I'm talking about so you can kind of sort of go, oh yeah, I get it. You will notice that escrows never do addendums halfway through an escrow because they understand, they have legal people advising them, they understand that an addendum would have been part of the original escrow instructions. But when the buyer and the seller decide to change the price, you don't do an addendum in escrow. Escrow creates an escrow amendment because that is the correct way to do it. Now, it's not life and death. If you do an addendum when you should have done an amendment, no one's going to cook you, no one's going to boil you in oil, and you'll probably get away with it contractually, but it is not the right way to do it. So start being a little, be diligent in your use of addendums and amendments, and use the proper form. And like I said, the uh, change in a disclosure would be on an APD, amendment to a prior disclosure. Now, another thing I'll point out, if you look in the top here, the addendum generic, ADMGEN, that's an addendum where the people who are signing it are not buyers and sellers or landlords and tenants. So they don't have the buyer, tenant, seller, housing provider at the bottom. So that way it doesn't, you don't have to cross out the buyer and put in, who is actually signing this. They're not the buyer. You're changing a document. It's not a purchase agreement. Okay. BMI. People in San Diego have heard this so many times they're sick of it, but the people in Irvine haven't heard it nearly enough times. So we'll start the chain now. And the San Diego people, if you know all this, great, good for you. Sometimes the best learning happens when you already know what you're being taught. The BMI is a form we require. And the reason we require it is I've had experience over the years. I can name agents who are big, big, big fans of the BMI. Why? Because they were sued or threatened to be sued, and the BMI cut that off at the very beginning. It saved them a lot of aggravation relative to claims typically that buyers make. What buyers typically do, and if you've been doing real estate for a while and you've ever had a problem, you maybe have experienced this. I've experienced it hundreds of times in trying to resolve problems. The buyer says, I told my agent that I was worried about this, that I didn't want the property if it had this, or I wanted to investigate something, or I owned the property before and it had an XYZ, and I want to make sure this property doesn't have it. And my agent didn't do anything about it. My agent didn't protect me. My agent knew I did not want a house in XYZ school district. They knew that. And they didn't confirm the school district. They misinformed me. So it's a he said, she said. I've had some pretty bizarre claims made by buyers that they insisted they told their agent. And of course, I called the agent and they said it never came up. I don't know what they're talking about. And now you got a he said, she said. Could we win that lawsuit? Maybe. Could we lose that lawsuit? Maybe. Would we like to avoid the lawsuit altogether? Because even filing a lawsuit and dealing with it takes time and money. You know, you cover the first 5,000 of the deductible, and I've got to get an attorney involved. There goes a couple of grand right there. Wouldn't it be nice that Walt can make a phone call to the buyer and say, what are you talking about? Or the buyer's attorney even. If you don't fix this, Mr. Klein, we're going to sue you and your agent. Well, that's kind of interesting. They were really, really, really concerned about whether or not anybody adjacent to the property smoked, and it was life and death. But I look here at the BMI, and all they talked about was how old the carpet was. If this were a life and death issue, wouldn't you think they would have listed that on this form? And folks, that has stopped lawsuits in its tracks. Septic tanks, horses being allowed on a property. I could go on things that, you know, the buyer was threatening to sue the company and the agent, would have never bought the house. My agent knew about it and didn't protect me. So with the advice of our attorney, I began years ago to require the BMI for no other reason. I know it's a pain in the neck for you as an agent, as a buyer's agent, but to protect you from those buyers who have very selective memory after close of escrow. So this is a required form, and when you represent the buyer. When you represent the seller, it is not required. You know, it's up to the buyer's agent to take care of this issue with the buyer. We're not here to advise the buyer as seller agents. So those of you that are listing agents and a buyer writes an offer, you don't have to worry about the BMI. Even if it's a dual agency, if you also represent the buyer, now you would worry about the BMI. Or if another agent in the company represented the buyer, that'd be dual agency. That agent would be responsible for getting the BMI executed. And you want to get this executed early in the transaction, preferably before the physical inspection, because any issues the buyer lists, you would want to bring it to the attention of the physical inspector. This buyer is absolutely worried about asbestos. So, Mr. Inspector, Ms. Inspector, as you go through this property, if you see anything that might be asbestos, could you make a note of it so that the buyer is aware of it and can pursue further investigation? Hard to do that a week before escrow closes. Oh, I forgot the BMI. That is almost as bad as not having one. So do this immediately. Congratulations, they accepted the offer. Go ahead and contact your lender, get that ball rolling. Contact your insurance agent. That's going to be a challenge. Get that ball rolling. And please fill out this form so I can guide you through the investigation of this property. That's what you want to do at the early beginning. And so this form has a lot of language in it, that has turned plaintiff attorneys around, stopped them in their tracks because we had it. So make sure you get it done early. Another thing, the buyer disclosure. This is where the buyer lists the things that are issues that they are concerned about. You create a text field in this area. You do not fill this out. If you're doing it digitally, you create a text field, they type in. If you're doing it, wet ink, whatever, you just hand it to them, say, please write it down. We've had challenges to the BMI by the buyers saying, well, I didn't fill that out. My agent filled it out. I just signed it. I didn't realize what they wrote. I've actually been in court and the buyer said that, and I was in court, and I pointed out to the judge, no, 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 no. Our practice is, and if you look at the document, it demonstrates our buyer's agent created a text field. Look at that typing, that font. That font is created by the buyer typing in this text field. The judge turned to the buyer and said, did you fill this out? To which the buyer said, mumbled something I don't remember. Okay. And already the judge was not giving the buyer much credit. So create a text field, have the buyer fill this out, the paragraph 3. And if the buyer says, I don't really know, nothing, have the buyer write none. A blank form's also been challenged. The buyer said, well, I didn't understand this. I didn't fill it out because I didn't understand it. So they type in none or write in none. So if you have any questions with the BMI, start using it. You'll get good at it. My experience is agents struggle with it the first couple of times. They don't have really mastered the dialogue. I'll be glad to help you, coach you through it, get the BMI executed. Okay, now let's go on to the next form. I want to speed it up a little bit. And that is selling your own or a relative's property. All right. So the first form in your handout, and this is all available on a tab within Agent Hub. When you go to contracts, forms and contracts, there's a tab selling your own property. And when you click on that tab, these forms appear there. I think these forms are also in the general list of forms as well. All right. So this is an explanation of what you need to do. So if you're taking notes now, that's great. You sell your own house a year from now and you forgot this webinar and you don't even, have time to access it and listen to it again. I understand. You can just go there and click on this form and this form will tell you the things you need to do. Now, the first paragraph talks about the definition of relatives. And if you read that, it's extremely broad. Anybody that even has any potential of being in any way related to you, even by marriage, not by blood, they would still be covered under the sell your own or relatives provision in our E&O. Okay, absent this, the E&O will charge a $20,000 deductible if they even cover it. And you will be responsible for that entire $20,000. So this is something you want to pay attention to, because you will not have this problem if you do what's on this page. It's 2 pages. Now it's a regular transaction. And like every other transaction, you don't need to worry about E&O uniquely because you sold your own or a relative's property. So the first thing is there has to be a home inspection, and it has to be by a certified inspector, any one of these certifications. And the good news is most inspectors are certified by one of these. What won't work is the buyer's favorite contractor. Well, I'm going to inspect it for him, or the buyer's father or husband or whatever, wife maybe, I don't know. They have to be a certified inspector. So you'll want to make sure that when the buyer hires an inspector, the buyer is hiring a certified inspector. Okay, there has to be approved home warranty in place. Doesn't matter who buys it, just has to be a home warranty. And approved, I wouldn't worry too much about that unless your buyer wants to get a home warranty from some company you've never heard of. If you've heard of the company, I won't list them now, but most of the home warranty companies, they're all fine. We just want the E&O wants a reputable home warranty company. The list of forms that have to be a part of the transaction, not big change from what we require anyway. So I wouldn't worry too much about it. Just make sure, because if you forget a form, Lindsay and I or Erica and I, we're not going to cook you. We're not going to not pay you. We're going to remind you. Lindsay's going to remind you. Erica's going to remind you. And if you close without it, we're going to, I'm going to scold you because you shouldn't be closing escrows without these forms, but you're still going to get paid. One of these forms missing and there's a claim and you are selling your own property, you run the risk of it not being covered or that $20,000 deductible kicking in. So a little extra teeth in getting the forms you're supposed to get anyway. The AD, the affiliated business disclosure if appropriate, the TDS, the AVID, the SBQ, the FHDS if appropriate, the lead-based paint disclosure if appropriate, and the earthquake hazardous report. That's that one page that the seller fills out. Those two forms, the lead-based paint for property prior to 1978 and the earthquake properties prior to 1960. The statewide buyer and seller advisory is one of our required forms as well. And then finally, a qualified substitute statement or the actual FERPTA in the file. All right, so that should be not a challenge at all. All right. Additionally, the natural hazard disclosure report, that front of the natural hazard disclosure, which is required by law, that has to be signed by the buyer. And now, if it's a flip, and in fact, if you're buying a flip, but if you're selling the flip, then a complete list of all repairs and improvements. And of course, we also require, excuse me, require who did them. And again, that's pretty standard practice anyway. And now there's civil code. I've talked about that. And this pertains to 1 to 4 residential units and oh yeah, and the final thing, the Remax Connections Premier supplement to the real estate purchase agreement, which is also available in Agent Hub. That must be part of the file. That is not a C.A.R form. So let's talk about that form. That form's a 4-page form. And the first 2 pages are basically little paragraphs about different inspections the buyer can have. And the buyer and the buyer's agent must initial each paragraph. The 3rd page is a disclosure that the brokers are not verifying any information provided by others, and a paragraph advising against the dangers of waiving an inspection. And then finally, there's a paragraph that says we cannot guarantee the condition of the property. We're not responsible for defects observed or not, tax advice, all the kinds of things. This was a form. It's actually years and years and years ago, E&O told me what they needed documented, and they had a form which is about the most unfriendly, user-unfriendly form, the most ridiculous structure of a form. I said to myself, no agent is going to be able to walk their buyer through that form. So I rewrote it years and years and years ago, and then had it approved by the E&O company. And, a little pat on my back, the E&O company said, yeah, we like it. Can we use it for other companies as well? So I said, yeah, of course. And so this form was blessed by the E&O company to accomplish what they want to accomplish. The buyer elects which inspections they want. If they don't know which ones, suggest to them to elect all of them, and then we'll amend this with the inspections they don't get. Whether they initial it or not, they can still get an inspection. But this is sort of the fact that they don't initial a soils inspection. I'm not going to do that. And then later they file a claim about the soil. One of the first lines of defense, that I or the E&O would use is, look, you were told back here further up in the form about the value of a soils inspection, and you elected not to get it. And now you're suing because there's a problem with the soil? See, that's kind of the dialogue, which we try to nip claims in the bud, just as E&O wants to do the same things. They're waiving the following inspections. Notice they're not waiving a physical inspection. When you're selling your own or a relative's property, a physical inspection cannot be waived. There has to be a physical inspection, and it has to have been performed by one of those certified inspectors. And then finally, there's a signature page. So this 4-page document is what you would add to any transaction where you or a relative of yours has an ownership interest in the property. And then finally, an amendment to the supplement. You would not use this unless you needed to amend the supplement. And I thought I changed these, or actually, I know I didn't, but I thought I asked Lindsay to change them. I think I must have forgot. I'll ask her now. So it's on the recording. If she can change those dots to little boxes, for now, until she does, she'll do it pretty quickly. Probably done before before you know it. So you will check off the inspections the buyer said they wanted. Now they don't want them. So then they're going to initial the ones they decided they don't want. So back to that original supplement, if they don't know whether they want it or not, suggest to them to initial it. Whether they initial or not, they can still do it. This is more a paper trail to protect you as the owner of the property. You were more concerned about the profit you were making on the house than protecting the buyer. Well, the buyer's not my client. I don't know. I have to protect him. No, you took advantage of. That's the kind of dialogue back and forth. Or the buyer was your client. It's even harder to defend yourself. So this paperwork helps us do that. Well, they didn't ask for this inspection, or they did, but then they waived it here. And again, you'll notice no physical inspection can be waived. And then it's signed by the buyer and the seller. Any questions, contact me about these forms. Now, the next thing is some of those C.A.R forms are required by law. So I'm not too worried about whether a TDS, the other side says, well, we're not going to give you a TDS. Well, the law requires you to give us a TDS. Here's what's not required. That supplement. Here's what's not required. The buyer has to have the property inspected by a certified inspector. So this is important. You must, when you are selling your own or a relative's property, put this language, paragraph 1, and if you want to make it a different paragraph number, this is editable. But don't edit the body of this. Don't change a single word. But I believe it's in Agent Hub. Lindsay can correct me or not. With a little bit of trepidation, we put it in Agent Hub in a way where you can cut and paste it, which I believe makes it sort of like a Word document. So please don't change these paragraphs. You will destroy the effectiveness of what this is supposed to do and compromise whether or not the E&O is going to cover you. But the only thing you could change is the paragraph number, I suppose. So cut and paste this onto a counter. And the buyer is going to agree to this. I've not had any buyers that I'm aware of not enter into a contract with this on it. We've had buyers who, after the fact, said, well, I decided not to get an inspection. Too bad, it's in the contract. Here's a notice to perform to get the inspection. We've had agents forget to put this in the counter, and the buyer say, I'm not doing it. You can't make me. And you can't because you forgot to counter this in. So cut and paste this exactly onto whatever counter you're going to create. Add to the counter anything else you need, price, escrow, all that. Hopefully it's our escrow. But the buyer is then bound to get the property inspected by a certified inspector. The buyer is informed that the home warranty will stay in place. Funny, I have to say that, but on more than one occasion, we've discovered buyers have canceled the home warranty immediately after the close of escrow to get the refund and put a few dollars in their pocket. So I had to put this in there. And then finally, that they would execute the supplement during their contingency period. All right, hopefully no questions on that. Now I'm going to zoom through the Agent Hub forms, and I broke that into 2 categories. Agent Hub forms that may be required as appropriate, and then Agent Hubs that are recommended as appropriate. Okay, so let's look at the ones that are required if appropriate. So the first one, of course, is the affiliated business disclosure, arrangement disclosure. And to make one comment, you should do this immediately. We've had problems where it's done later and then the buyer doesn't want to sign it or the seller doesn't want to sign it and you're halfway through a transaction with one of our affiliated uh, companies, you can get in serious trouble if that happens. So make sure you get this executed right away. It's very problematic. This form is dictated by federal law. The structure of this form is dictated by federal law. So the regulators are looking at this, and so you have a problem later. You've specified our escrow company, but you didn't get this form executed. And then after the fact, we have a problem, or you ended up using DG funding. And then after the fact, an issue comes up. We're dead in the water because this form wasn't done. And you want to do this form early because they're consenting to using these services. If they don't consent to use the services officially and they use the services, then at the end of the transaction, there's an issue. I've had people raise this issue. Well, wait a minute, this affiliated business form was signed yesterday and we're going to close escrow in a week. That's a problem. Okay, so that's required. No, shouldn't be too much of a challenge for anybody there. The next form is the addendum to the disclosures regarding agency relationship. This is another form. It's a pain in the neck, but it's very simple. Our E&O has successfully nipped lawsuits in the bud with this form, and they've done this across the country. This form, again, years ago, the E&O companies, and it turns out about 50% of the time we're with the same underwriter, the same company that's underwriting the policies, and we're with that company now. And why? Because they are, I think, the largest E&O company in the country, and they have pretty, good rates relative to other companies. So this a version of this form they use throughout the country. California is a little bit unique because California has most of this language on their form. But this is redundancy that gives the E&O company clout when they're trying to negotiate a claim before lawsuits even filed. It gives me a little bit of clout when I'm trying to negotiate a claim before it even goes to the E&O company. Because once it goes to the E&O company, it's somewhat out of my hands, and the meter is on relative to attorney time. So this is a required form. You can get it from Agent Hub, and most of you are using it. Those of you in Irvine are now starting to use it, and I appreciate that. Okay, the next form. This is important when there's a BMI, there's always a BMI if you represent the buyer, that has something on it other than none. Imagine they put down, yeah, I'm concerned about asbestos. And then halfway through the transaction, you say, you know what, you say in the BMI you're concerned about asbestos. The inspector pointed out that they don't know any, they don't inspect for asbestos, and that we should hire an asbestos inspector. Okay, well, let's line one up. Okay. All right, that'll cost you $350 or $400 or $500. Well, I don't want to pay that. Well, that's what you have to do to check for asbestos. Well, then forget it. Well, now you close escrow. They find asbestos. They have a selective memory. Folks, this has happened more than once. They have a selective memory. I told my agent I didn't want asbestos. It's even on your form. And he allowed escrow to close, and nobody checked for asbestos, and my ductwork has asbestos on it. By the way, ductwork up until 78 was lined with asbestos, especially not all ductwork, but the flues, the furnace flues, and water heater flues. That was standard. You got a loaded gun. You got the BMI saying asbestos and a verbal he said, she said. So when they say now, forget it. Or even if they got the inspection, this is saying they're satisfied. If there's anything other than none in that field that I talked about with the BMI, you want to execute this. And as an extra benefit, I threw in, again, with the blessing of our attorney, we talked about this. What do you do when agents elect inspections and they don't get them? Well, that's a good question too. How do you document, oh, I decided I didn't want that inspection, because I didn't know it was going to cost me that much. So we'll throw that in too, Walt. That's a good idea. So execute this when there's a BIE that has any inspections other than a physical inspection, because you're going to waive the physical inspection. You're going to waive any other inspections that the inspector recommends. And the BMI, anything on the BMI. Hope that's clear to everybody. If not, maybe put something in the chat or bring it up after I'm done. And of course, always call me. This is an important form in conjunction with a BMI, but only when a BMI has something other than none. When it says none, you don't need this form. Okay. And I would say, Lindsay, correct me if I'm wrong, at least 50% of BMI say none.
Correct. A lot
Yeah,
do.
exactly. It's okay. Land purchase advisory. This is a great little tool, by the way. You meet somebody and they want you to take out and find land because they want to build their dream house. You say, okay, no problem. I'm happy to help you. And you think to yourself, oh my God, I don't want to sell land. I don't want to go all around. And what do I know about land? And plus the commission will only be half of the house they want. So you say, now, these are some issues that you're going to have to investigate in order to build your dream house. And you show them this two-page form, they are going to have second thoughts. I've had more than one agent tell me they use this all the time with buyers who start out by saying, we think we'd like to buy a lot. They're looking in Fallbrook and maybe we could buy a lot and build our dream house. And you'd rather sell them a house in Fallbrook. Well, you'll sell them a lot, but they should know what they're up against. So this form, anytime a buyer is buying land, especially when they indicate to you they intend to build on it, have them execute this form. This is just an advisory. And again, an attorney who was a developer in a prior life. I was a general contractor, a little bit familiar with development. I didn't do a lot of development, but I worked with developers as a general contractor. I am familiar with a lot of these issues. He was familiar with a lot of these issues. And so we put together a list of things that a buyer should investigate if they're thinking of buying land to build on. And if they don't investigate this and you never said a word and they find out that, the land doesn't perk, septic, those of you know septic, you know what I'm talking about. The land doesn't perk. Now they're stuck with a piece of land they can't build a dream house on. They're going to blame you. They have selective memory. They told you they were building their dream house and you didn't tell them to have the soil checked. All right, so that's not a common form, but we'd like you to use that. And then finally, the mold advisory, straightforward. I know it's redundant. Mold is the number one specific property issue that adds significantly to dollar damages. And so we want to paper the file. That's what insurance adjusters, that's a term they will use. Paper this file with stuff to protect us from people making claims against us over mold. So this mold advisory, pretty straightforward form as well. All right, and then finally, this is in flux a little bit, but you can have your corporation paid by escrow. But you have to, this is a DRE regulation. You cannot do a blanket request. We will get busted for that. We would be paying a corporation to do licensed work. Corporations can only do licensed work if the corporation's licensed. Mike's corporation is of course licensed. Those of you that want to be paid into your private corporations, those corporations in most cases are not licensed real estate agents or brokers. So I can't pay those corporations unless we can document that the corporation didn't do the work you did, but you want the money that you earned to go to the corporation. And some escrows will tell you it's not legal. It is legal. I actually got the DRE documents. It is a little bit in flux because the DRE and the Department of Corporations, they're fooling around with some requirements for the escrows. But for now, we're still, I think, Lindsay, we're still allowing escrow to be asked to pay corporations, I think, right?
Yeah, there's very few escrow companies that will not accept a CDA.
Okay, all right. So that's good news. So you have to fill this out so we have it in the file. I'm requesting that my responsible broker, that's us, pay compensation earned by me. That's your name. Your name. It was earned by me. This language comes right from DRE. And Lindsay created this fill-in field so you didn't have to type one up every single time. You just get this form in Agent Hub. It's a fill-in. That's why these things are blue like that. It wasn't easy to copy this and put it on a slide, by the way. But I figured it out. So then the property address, and then two, the corporation you want, the money you earned for working on this property to be paid to your corporation, signed and dated. We will not pay a corporation. We will not put it on the CDA without this form executed because the DRE requires it for each transaction. All right, that takes care of, I think, the required ones. Here's the recommended ones. I think I'm right on time. This is good. All right, and these are recommended if appropriate. And some of these forms are quite handy. And I frequently, when agents call me with a question or a problem, I refer them to this form. So I wanted to point these forms out to you. I'm not covering every single form in Agent Hub. Like I said, some of them are probably not nearly as important as others. They're there if you need them. But the ones I'm talking about today, you should be aware of and access them as appropriate anytime you need to. All right, so the first form I want to talk about is the advice against releasing funds early. We're not the principals. We don't dictate whether the buyer allows the seller to get the deposit. But as agents, we have an obligation to recommend to the buyer that there are problems with that. You release the deposit, the seller defaults, now you got to get the deposit back, and the seller spent the money. Buyer's going to have selective memory. Well, my agent said it was okay. Well, my agent said it was the only way I could get this extension. Well, that might be true, but we're telling you don't do it. Maybe you don't get the extension. We're telling you that it's not a good idea. Now, you can verbally give them permission to go ahead and authorize the release of deposit. I understand, the sellers, your in-laws, and you're going to move in, on Monday, and they want the deposit released to them on Friday, and these are your relatives, and they need to make a house payment, and the escrow hasn't closed yet. So, you could do it. I might do it if I were you, but I need to advise you there's risks to that, even with your relative. So I'm going to send you a form where I'm documenting that you are being advised not to do it, but you get to do what you want. See, that's a little bit of a butchered dialogue. I probably could do it a little better if I wasn't looking at the clock and wanting to finish on time. But you can give them permission when it's appropriate and they really want to. It's their choice. We have an obligation to point out the risks. This is a very important form to execute anytime the buyer authorizes the release of their deposit. The same with granting possession before close of escrow. Yeah, I know he's your son-in-law, that's your daughter. Of course, you're going to let him move in. But I need to tell you, they don't own the house. You do. And, possession was at close of escrow. But I can understand. That usually doesn't come up that often. It's not an issue. But it comes up where they're friends or they like each other and they're just trying to cooperate. So, sometimes it's not such a good idea. We need to go on record as saying it is in general fraught with problems. So here's RE/MAX advice against granting the buyer possession before close of escrow. An alert to wiring scams. This is a very good form, again, to have in the file. It's probably duplicative of their escrow instructions of the RPA. But once again, we're protecting ourselves from a buyer who wires the money to the wrong place. So this is a good form to execute whenever there's a wire involved in your transaction. I want to talk about this a little bit. I won't go through this form in detail, but I'm going to point out a couple things. Arbitration, it's been my experience that agents, I did the same thing when I listed and sold, assume that arbitration's a good thing. Folks, there are cases where arbitration may not be the way to go. I can tell you how impactful that statement I just made is. C.A.R. took all arbitration clauses out of any contract between brokers and principals. So you can look at the ICA, and arbitration, there's a version of the ICA that doesn't, that's between agents and brokers. Arbitration was taken out. You can look at the BRBC and the RLA. That's more specific to my example. There is no arbitration provision in the RLA or the BRBC. Why? Because not automatically is arbitration the right thing. I will tell you personally, when I'm involved in any contract, Remax, Connections, or now Premier, get involved in, I generally do not agree to arbitration on the advice of the attorneys who have represented us in the past, who I have a high regard for. And that doesn't mean arbitration's bad. And so you don't want to tell your clients, look, I just got off a webinar and my general manager said arbitration's bad. I'm not saying it's bad, but I am saying you should enter into it knowing what you're doing. And it's not, oh yeah, it's a good thing, it's cheap, it's fast. Yeah, do that, do that. That's legal advice, and you should avoid it. That's why C.A.R. created this document. They wanted to tell agents, stop recommending arbitration because sometimes you'll find out arbitration is bad. Now, arbitration's good mostly for all the reasons you all know. It tends to be faster, not necessarily. It tends to be less costly, not necessarily, but it tends to. Here's what arbitration is not. It is not appealable. So you get a bad decision in arbitration because you think the arbitrator doesn't understand the law? Too bad. You get a bad decision in Superior Court because the judge didn't understand the law, you appeal it. And then go all the way to the Supreme Court if you want. And by the way, that happens all the time. All the case law that we function under is a result of a judge at the lower court making a decision that was ultimately ruled as a bad, wrong, incorrect decision. And the appellate court corrected it, and that became law. Superior courts do not set case law. No other superior court is bound by a decision of another superior court. But all superior courts are bound by the decisions of appellate courts. So you can't appeal an arbitration. So you get an arbitrator, and they exist. Unfortunately, in general, we like to use arbitration by licensed, real estate agents with at least 5 years experience. I think that's what the boilerplate of the arbitration clause says. And we want people that know what they're doing in real estate to be an arbitrator. But there are entities, including small claims judges, who haven't got a clue and make factually wrong decisions. And a small claims decision can be appealed, by the way, if you're the defendant, not if you're the plaintiff. So I clarify that. So if you are suing somebody in small claims court and you lose and you want to appeal it, you can't. If you're the defendant and lost in small claims court, you can appeal it. But I get off the track here. Arbitration decisions are not appealable unless you can prove there was a violation of procedure. In other words, the arbitrator was related to one of the parties. Well, that's you can set that aside. So that's the first issue that I have personally with arbitration. And C.A.R., by the way, points that out in this form. I think paragraph, gee, I went so fast. I think in paragraph page 4, where they talk about what are the advantages of arbitration, what are the disadvantages, not appealable. The other thing about arbitration, which I think is a problem, is you can't bring anybody into an arbitration unless they agree to it. But you can bring somebody in if it's a civil suit in court. So you want to countersue the inspector because the inspector should have discovered this, and you're being sued by the buyer, but you think the buyer hired an inspector who was incompetent. So you countersue the inspector. That's an easy thing to do. Now it's going to cost you some money to actually prosecute that claim, but you now join the inspector now is joined into the litigation. He doesn't have to agree to that. That's the way law works. But if you're in an arbitration and you'd like to bring the inspector in, the inspector has to agree to be a party to the arbitration. What's the chances of an inspector who you are making a claim against saying, oh, yeah, yeah, I'll join in on your arbitration so I can end up losing and paying money too? So that's not going to happen. So here's what I'm saying. What's the point of all this? You should have a copy of this on your computer, have a paper copy in your briefcase. And when a buyer says to you or a seller says to you, what's this arbitration? Should we do that? I'm not an attorney. There's pluses or minuses. Here's a quick form. Take a look especially at the last couple of paragraphs. Here are the advantages. Here are some of the disadvantages. I'm jumping around a little bit. Uh, paragraph 8, question 8, advantages, question 9, disadvantages. You should make your own decision. You should avoid boilerplate recommendations of arbitration. Okay, RE/MAX boundaries and corners and septic system advisory. If you're selling a property that doesn't, not in the middle of suburbs, and the fence may not be on the property line, but it's pretty close. Properties out in the outback, if you will. With all apologies to all of our Fallbrook and Valley Center agents are not outback. I know that, but you sell property where, boy, I tell you, that corner is somewhere by that oak tree and that big old rock. I think there's a monument out there. So you would want to be aware of this. And the agents in Fallbrook, they're very aware of this form. Agents who work in Valley Center, they're aware of this form. I don't know how much Irvine agents work in a much more rural setting. I'm going to be learning that over the next year. So be aware of this form and go through it. The next form, when you sell a FSBO, and the FSBO agrees to pay you, and you're not going to represent the FSBO. Why? And besides, or anyway, you're not obligated to represent a FSBO. The FSBO can pay compensation to you on behalf of the buyer, just like a listing seller can. So you can be paid by the FSBO. You're not obligated to represent the FSBO. My recommendation is if you can avoid it, why do it? So you're not representing the FSBO. You want to give this FSBO, this for sale by owner, this advisory, this very important. And it basically makes it clear, I don't represent you. And I'm not, and it protects you from agency by action. You create an action, you do an action that tends to create an agency. They're going to argue because you did that, you're the seller's agent. And one of the things you could do that would make that possible is you provide a bunch of forms to the FSBO. Now, the law allows you to say, look, I'm giving you these forms, not because I'm helping you that I represent you. I represent the buyer, and you need to fill these out and give them to the buyer. So yeah, you don't have a TDS, I'll give you one. You don't need to write your name out on the bottom. You use this form, you give them the TDS, they fill it out, and then for the record, you gave them the TDS because your buyer is entitled to it. And this form is how you document that. Pretty straightforward there. Okay, home inspection waiver. We like this form. I like this form. You can do a C.A.R waiver. I think doing it twice with 2 forms is excellent. Redundancy, folks, I can't tell you how powerful it is. The buyer says, well, I didn't understand it. I didn't realize what I was doing. I signed it because my agent put it in front of me. Okay, that explains the BIW, the buyer inspection waiver. What about this RE/MAX home inspection? Oh, I didn't understand that one either. I signed it because my agent put it in front of me. The judge is going to look at this buyer as, man, if there's another form in there, I'll bet you'll say the same thing. I don't believe you. That's exactly why redundancy is good. It eliminates or goes a long way to eliminating an argument. Well, I didn't really realize. Well, did you realize this one? And by the way, this one's in plain English. I need to look at it, make sure the number's right, but I even talk about the price. Inspections are relatively cheap compared to the problems you might have not doing one. So this is I highly recommend when you're waiving a home inspection, use the C.A.R form and this form. Redundancy is a good thing. List of inspectors, not a huge deal, but some agents are nervous to provide inspector lists. So provide a list of a recommended inspector. I'm going to give you a list of 3 inspectors. Many of the people I represent are very happy with the first guy on the list. That's a very nice dialogue. You provide them this form along, and you will prevent yourself from having any kind of a negligent referral claim. Those claims are harder to make than you realize. For God's sakes, or excuse me, my language there, for heaven's sakes, don't recommend an inspector who's being sued or lost their license. That you'll get in trouble. But if they're a licensed inspector and you have no knowledge that they have screwed up, you're pretty safe in recommending them. Don't worry too much about it, but there's a nice form here for you. Again, with a title. It's a nice form. People have questions about title. There are some agents in the company that use this form automatically. It's a nice advisory to pay attention to that title report. And it even says that I can arrange for you to meet with it, especially with charting and walking the easements. There are title companies that'll do that, I know. And this form kind of talks about that. It's a nice form to have in the file. The final one, I think it's the final one almost, and this is when you are buying a Remax Premier or Connections listing. So now you're buying it. Now that's a bit of a problem, right? Because we have a fiduciary duty to the seller, which among other things say get as much money as possible. And, you're buying it. You have a duty to yourself to try to save some money buying it. That puts you in a very tough spot. Some brokerages will not allow it. Some E&Os will not allow it. Again, we negotiate permission to do this, and we have a form that goes a long way to protecting us. Now, the importance of this form, I'll show you, is where you are talking about how much money you're going to make. And this form is not designed to minimize your profit. It's not designed to, I'm going to buy your house, it's a wreck, and I'm going to sell it. But, I got all these expenses, and I'm probably not going to make a nickel. So I'm going to pay $700,000 for your house. I'm probably going to have $100,000 worth of expenses, and I'd probably be lucky if I can even sell it for $800. I'm going to break even. That won't help you in court. This form is designed to exaggerate. We call it, I have an agent, I love her dearly. She calls it, and I call it the rip-off letter. She's called me a couple of times. Well, where's that rip-off letter? It's an agent hub. Oh, okay. And you're not ripping anybody off, but you want to talk about here's the sale price is 500,000. Your house is a wreck. I'm probably going to spend, at least 100, but maybe 150. Okay, I'll put in 150. Or no, only 100. I'm probably going to spend 150, but maybe 100. So I'm going to only put in 100. See, I'm not maximizing how much I want to spend. I'm going to minimize it. And my profit, it could be easily 200, 300,000. I'll be lucky if I make 150, Walt. This is not a tax document. This is not part of your bookkeeping. This is a form where you're telling the seller, look, I'm going to make some money here, maybe more than you will like if in the end, you're going to think, oh, I should have kept it. I should have fixed it up. I could have sold it. You ripped me off. That's the origin of the rip-off letter. We don't want a seller to come to us later and say, I got ripped off. You took advantage of me. And, I have no obligation to protect a seller I don't represent. And by I mean anybody within this company. I have every obligation to protect the seller we represent. So from time to time, agents, and it's happened multiple times, come upon a listing that we have, maybe their own listing. You know what? I think I'll buy it. So you use this form to document you're going to make a ton of money, probably more than you're really going to make. I have one agent argues with me. I tell him, no. You want to make this, if you want to make this make too much money, not too little. This is not a form to show how little you're going to make. It's a form to show how much you're going to make. All right, folks, that's it. 4 minutes over. That's not too bad. I'll take it. Lindsay, do we have questions?
Yes. So going all the way back to the RCSD, someone wants to know, is this applicable for a commercial property with shareholders as well, where the principal shareholder can sign this?
Yeah, that's an entity, right? So that there's shareholders are shareholders of what? Some kind of an entity, and the entity is buying it, and so they're an entity seller. If I'm understanding the question correctly.
Is that right?
Yeah, thank you.
Okay.
Okay.
And then Linda asked us a few questions. One of them I wanted to clarify with you, Walt. That is how the trustee should sign their name exactly.
That's a great question because it's going to cause me to answer more than your question. How trustees sign, courts have been somewhat lenient about that. The preferred way is they sign their name with a comma and then trustee or co-trustee. That's what they should do. They should for sure not sign the Walt Klein Family Trust
Mhm.
trustee because Walt Klein Family Trust doesn't have a hand, didn't pick up a pen. So they sign Walt Klein and then comma co-trustee. Now, power of attorneys far different, and courts have invalidated contracts incorrectly signed. So, a power of attorney, think about this. The power of attorney, the attorney doesn't have signing authority in the same sense that a trustee does. The attorney, in fact, has permission to sign the principal's name. That's what a power of attorney is. So, with a power of attorney, so Diane grants Sally a power of attorney. Sally can sign for Diane, but she has to sign Diane. So with a power of attorney, it's three lines, if you will, three statements. One, Diane Klein, because Diane gave Sally a power of attorney. She doesn't want to bother with this. I'm going to have Sally take care of it. So the power of attorney, Sally, signs Diane, signs the name of the person who granted the power of attorney, then signs their name, Sally, and then POA or attorney in fact, a statement of why her name is there, Sally's name is there. Great question. Hope that answered it.
The next question is about the flips.
Yes.
On the complete list of work or upgrades on a flip, does it have to include the price paid or just the list with the full contractor information?
Great question. And no, it doesn't. And sometimes that's why you get pushback. You, as the buyer's agent, are asking this from a flipper, and the flipper's not wanting to give you anything. None of your business who the plumber is, because he's afraid you'll see that he paid the plumber $1,000 and he's adding $10,000 to the price for the plumbing repairs. I don't know. So you can say, I've said this many times when I've helped agents get paperwork that they're trying to get and the flipper's not giving it to them. Look, you want to black out the price that you paid for it. That's none of our business. I have no problem with that. So you black out the price. Yeah, the cost that you paid is not uh, uh, material. Now, to add to that a little bit, sometimes I answer more than I ask, and sometimes I get in trouble for that. When you give estimates, a buyer, a seller rather, has a property looked at and gets an estimate with a scope of work that needs to be done. That price is probably material because that tells the buyer this is what you might have to pay if you buy this house. Now, if the seller does it, then that price is not material. It's the work that was done. Hope that makes sense.
Kind of along the
Kind,
same lines. Oh, go ahead, Eden.
yeah, so kind of. My question was more so in order to prevent a mechanics lien, and you mentioned blocking out the price, which I like, but are we like, is that best practice to request the actual paid receipts? Like they can block out the price, but that way we have it later down the line in case they hired a subcontractor or whatnot.
Yeah, you could. Now that's and I maybe I don't want to get in the weeds here too much on this call. We can talk directly. Uh, the If you're concerned about a flipper having hired contractors, first of all, only contractors and actually suppliers, only suppliers and contractors can file liens, or people who are laborers hired by a contractor. Uh, Handyman don't have the ability to file a lien. Uh, if you're concerned about that, when they give you a list of repairs and who the contractors are, you can ask for lien releases from those contractors. And prices don't interfere enter into that at all. A lien release will not have a price on it. We've been paid in full. We have no claim. So that'd probably be the best route to take. Uh, there's a limit on time of when you can file a lien, and certain notices have to be provided. So if you're buying a house that was fixed up 6 or 7 months ago, uh, there there's not going to be the ability of any of those contractors to file liens.
Thank
Um,
you.
regarding selling a relative's property,
Mhm.
if the relative's purchasing an auction or an REO with no utilities on, completely as is, and the certified inspector told the buyer they would be wasting money to have the property inspected, but are we still requiring the buyer to pay for inspector and have the report state no utilities were on and inspection is incomplete?
Yeah, they might have to do that. They might have to limit the scope of the problem. If this comes up, that's kind of unique. Call me and let's talk about it. Let me give you, again, I'm answering a question you didn't ask, but kind of to give you an example. We have a very good agent. I hope he's on the call. I won't name him, but he's a good guy. David builds houses. They're brand new, and he provides, warranties. And he asked, and I don't fault him for asking, if we could waive the requirement that the buyer have the home inspected and to buy a home warranty. I mean, he's providing statutory required warranties. E&O said no. So if you are helping somebody a relative buy an auction property, then you might want to call me so we can look into it a little bit. Because you got to start with this. E&O is going to look for reasons not to pay a claim. So that's what all this is about. We want to make sure that we're following the guidelines so they can't say, I'm sorry, this isn't covered. Now, the good news is I'm pretty good at covering those. And like you can see from this class, we've gone a long way to documenting what we need to document so it can be covered, because that's the advantage of being an agent. It's wonderful that you're an agent and can help your mother sell her house. Nope, sorry, mom, I can't represent you. My E&O doesn't allow it. You got to go hire Redfin or something. That's crazy. But that's what E&Os start with. So we go through this little exercise. Number one, pay extra. And number two, guidelines that we have to follow when we do what they don't like us to do.
Do we have to have the ABA completed if none of the affiliated businesses are used?
Well, technically, the answer is no.
Right.
We ask for it all the time because here's the concern we have. At the last minute, the buyer's lender can't perform, but our lender can. More than once, we've called Matt or one of the other gentlemen, and they said, "I can do this loan. Let me help you." And they run it through in a record time. And oh, you're worried about getting paperwork and getting blah blah and nobody thinks about the ABA. So in general, we like it as part of every file. But the fact of the matter is, you're correct. If we did not use an affiliated business, the ABA is not necessary.
And some agents will inform me that the other side will not sign it because we haven't used any of our services. And if you just add that email to the file, then that takes care of that.
Perfect. I
Yeah.
agree. Thank you. Thank you, Lindsay.
Can your corporation be filed or licensed out of state if we have an additional LLC in state?
For purposes of being paid?
Yes.
Yeah, I think so. Yeah. Whoever asked that question, if you want to email me, I'll check it, get an answer. But yeah,
He left the call, but I will ask him to
okay.
contact you.
Yeah.
Would the boundary form be used for vacant land?
Yeah, it could. Exactly. Yeah, basically, because it's the same thing, hopefully there's monuments out there, but it's a nice advisory. Anytime you're buying land that what I call is not sort of suburban, right? I'm not worried about it at all. You buy a property in Scripps Ranch. I have different opinions of where my backyard ends, and it's about 5 feet difference. But I don't care. It's no big deal. There's a fence back there. There's a bunch of eucalyptus trees and a hill. but it can be very important when you're buying land out in the country. So, you know.
If you're representing the seller and you have a roofer come out and they provide a proposal for work that they recommend, does that need to be provided to the future buyer when providing the seller disclosures?
Absolutely. That's a material fact. You now have knowledge about the roof. And the bad news is the cost is probably material because apparently somebody thought that needed to be done, and that's an expense that needed to be incurred. They decided the need wasn't that big because they didn't do it, but there is that estimate. That estimate needs to be provided. It's material.
That's it.
All right, folks, thanks so much for joining us. I hope I got your questions answered. I hope you have a better handle on the Agent Hub forms. As always, call me if any questions at all, and happy to respond. So
Can I
have a nice
ask
rest
one
of the day.
question?
Oh,
Can I ask?
Jamie has a
Yes.
question.
Yes.
Okay, for the arbitration in the purchase agreement, if one party just don't want to sign, the other party want to sign, how do we resolve that?
Well, it's resolved contractually, but you should make sure that the party who wants it understands this. The contract says that if both parties don't initial arbitration, there is no arbitration provision. So you could move forward with the transaction, but the party who wanted the arbitration cannot now demand it because the contract says in order for arbitration, same with liquidated damages, in order for this paragraph to be in effect, both parties must initial it. And if both parties don't initial it, it's not in effect. And you can proceed with the contract, but you don't have it. So if you represent the party that doesn't want it, you need to make sure they understand, look, we can go ahead with this transaction. You don't have arbitration. The seller, we can go back to the negotiation table and ask again. You know, if this is a deal breaker, I can tell them, look, this is a deal breaker. If you absolutely want arbitration and or liquidated damages, you need to have both parties initial. Does that answer the question, Jamie?
Yeah.
Okay.
Kim has one more question. Oh,
Okay, I think
sorry.
you might have just answered it, but I was going to ask
Okay.
that same question for liquidated damages. I was responding to on the seller side, we received an offer and the buyer did not initial next to liquidated damages. So I wasn't really sure how to proceed with that.
You counter in that the buyer will do that.
Okay.
And then you make sure he does, but you have the counter where the buyer agreed to do it. And you can
Okay.
go back and then initial that.
Okay. Got it.
And who, Depa, you had a question?
Deepa, did you have a
Deepa?
question?
No.
Oh.
Wonderful class. Thank you so much.
Oh, yeah,
Yes.
thank you. Yeah, you're
Thank
very
you,
welcome.
Walt.
Thank you.
All
All right,
right.
folks. Have a great day.
Bye, everybody. Have a great
Bye-bye.
day.
Bye bye. Have a good one.